Do you have a temporary custody order? You better hope it's still temporary because it might have become permanent. Here's how to tell. I'm Jessica Arthur with Cape Fear Family Law. Today, I'm here to talk to you about a case out of Carteret County. Unfortunately, it doesn't have a lot of the juicy details, but it's a really important procedural case that can have a big impact on you if you have a custody order in North Carolina. We're dealing with a family today out of Carteret County. They had a little girl. They weren't married very long, but they immediately filed for custody. I think she was about two and a half when they filed for custody. And they got a temporary custody order pretty quickly after that. The temporary custody order allowed for dad to have every other weekend. It had some weekday visitation. It had some other things built in there for holidays, but didn't really address summer. They came back a couple months later and they modified it to really take away the weekday visitation. They didn't really say why, but it was modified. So they got their original order in January. Their next order came down in the spring. And then they didn't go back to court for any other hearings specifically for months. However, the important procedural part is that they kept filing motions to go back to court. So their original case started in early 2019. Around December of 2019, they actually filed motions to be able to go back to court to address custody, to address some specific holiday visitation. It doesn't appear by the court record, or at least that the Court of Appeals could see, that there were orders entered from that, but they were filing calendar requests at that time. So really there was only 9 months between the modification and the next calendar request. Then we all know what happened in early 2020, right? COVID hit. Lots of things happened with this case, so it really wasn't able to be heard again until 2022. But there were calendar requests all along the way. When it was finally heard in 2022 in Carteret County, the judge there determined that there had been so much time between the temporary order and them getting back to court that he said their temporary order was permanent. And that makes a huge difference when you're going back to court, because if you go back and watch some of our videos, you'll find out to do a motion to modify, you have to hit certain hurdles to even be able to let the judge make a ruling on your case. If you come from temporary to permanent, you just have to go through your regular case. You don't have to hit the significant change of circumstance that materially impacts the minor child. You can just go through and show what's best interest. So that's a huge difference, especially for us attorneys. We want to make sure that we get in there on our permanent custody hearing. That's so much easier to go in there and put on that evidence. So the judge ruled it'd been so long since the temporary order that it became permanent. Us attorneys are constantly talking amongst ourselves, like, when do we think a temporary order becomes permanent? Because the Court of Appeals has not been super clear about that. Now, we do have the test, the center test, and I'm going to go over that because the Court of Appeals did go through that and made it very clear that is a test that needs to be followed still to this day. The first rule, of course, is, did the temporary order specifically say that it was non-prejudicial? Those are magic words, y'all, that attorneys use in orders to make it very clear that no one's lost any rights or abilities or anything moving forward as far as putting on evidence, making their points in court to the judge. We want to make sure that that language is in a temporary custody order that is non-prejudicial. Now, this order didn't say that, but it repeatedly said temporary custody order. I think the appellate court noticed, like, every single time they talked about who had custody when, it specifically said temporary. They had handwritten on the consent order temporary repeatedly. Like, this was not, it said it once, it said it multiple times throughout the order. So the appellate court determined that that was enough to meet it. But if you, as an attorney, practice point, if it's a temporary order and you want it to be a temporary order, please, please, please put non-prejudicial. It will save you a lot of time and effort later, okay? The next part of the center test is, did the temporary order specify a time for it to be reviewed or for you guys to reconvene on this issue, and was it within a short amount of time? I worry that a lot of us are not putting that in there because, especially if you're a family court, if that means that, like, it's just going to show up on the calendar next. You want to make sure, if it's a temporary order, that you are putting in there that it will be reviewed in 6 months, that it will be reviewed on this judge's session, that it will be reviewed during the summer session, however your sessions work. But you want to make sure you put it in there that is specifically supposed to be reviewed within a certain amount of time. I really, after reading this one, I would not put it more than 6 months out, y'all. You want to make sure it's within close time period. So it has to specifically say when it will be reviewed. And the last part of the test is, did the order resolve all the issues? Meaning, were all the holidays, regular visitation, all that stuff, was that in there? A lot of times we're doing that in orders, right? Fellow attorneys, we're drafting orders that have all the holidays, all the visitation, everything laid out, because our clients want to test it first to see if it's going to work before they agree to make it permanent. They want that trial and error period where they can come back and fix little things without having to meet that huge burden of significant change of circumstance. So I know, at least in our county, we do that quite frequently. If you looked at the temporary order, it would look permanent. So you want to make sure that you're aware, if you resolve all issues, you don't have non-prejudicial, and you don't have that it will be coming back to court at a certain period of time, the court can absolutely determine that that's a permanent order. Period, end of story, without any time lapse. So keep that in mind. This court really went through that, and they determined that this order had those things, and it could move forward to determine if the time period alone then made it permanent, right? So the center test is a temporary order just how it's drafted, is it permanent? Or you skip over if you hit all those markers that we just went through, and is the time period enough that it makes it permanent? So we go through and we look at the time period for this case. The judge in Carteret County determined that it was actually 18 months from the time the temporary order was entered until they came back to court. The appellate court said that's not true. We have to look at when things are filed, because people can't help when things are actually heard. Like, judges get sick, COVID. I mean, that was unprecedented, right? I couldn't get hearings. I don't know if y'all could, but things like that come up. People get sick, different things happen, and cases get moved out. But if you filed to try to get your case heard, that should be honored, right? These people repeatedly, the records show that they repeatedly were filing calendar requests to get things heard. They went to mediation in 2020 on custody, and they just weren't able to come to a resolution. They went and filed multiple calendar requests for different issues for custody, some visitation. They were dealing with discovery issues throughout the case. So the court said you have to look at the totality of the circumstances, right? Each case has to go on a case-by-case basis, and you have to look at it. The Court of Appeals in this case determined that this was absolutely a temporary order, that they should go back and have a permanent custody hearing, and that they did not have to meet that burden of significant change of circumstance to be able to have a new order. But their order was clearly intended to be temporary. The time lapse when they went back and counted out the months was only 9 months, and that was not enough for it to become a permanent order. It's still a little frustrating as a practicing attorney that I don't have like that bright line time frame, right? Like, if you don't go back to court within a year, it's permanent. That's not what they're giving us. They're telling us you have to look on a case-by-case basis. The trial court gets to look at all those factors and determine it for themselves, but you absolutely do have the ability to appeal it up if that becomes an issue in one of your cases. So you want to make sure you keep all that in mind. But please, y'all, non-prejudicial, time period. Please make sure you're putting these things in your order. And if it addresses all issues, you definitely need to make sure you have all those, because the Court of Appeals has made it very clear that that's the standardized test to at least give us some sort of guardrails to make sure we're hitting. So make sure you follow it.